Litigation usually takes one or two forms. Trials in court, which we all know about, where a judge or a jury decides the matter, and arbitration, which not so many people have heard about. In arbitration, instead of having a court or a jury decide your dispute, what the parties to the lawsuit do are to find a supposedly neutral third party. You might hire a former judge or an experienced attorney, and you're hiring them and essentially giving them the power to decide the case. If you have bought a home or a car or a boat, or you have an employment contract, if you look in it, there's a good chance it might have an arbitration clause in it. So what will then happen will be, if a lawsuit's filed over that home or boat or car, one of the parties can look at the contract and ask that the case be taken to arbitration. Now, there are pros and cons to arbitration. In some cases it's great, in some cases it's not so great. Remember, only one person will be deciding the case rather than a jury. And for instance, maybe you get an arbitrator that has secretly some relationship with the other side. So there are risks to arbitration, and it can be costly. So you have to look at your dispute and decide whether it's best to take the case to arbitration or try to get it resolved in court. Very often we fight over what an arbitration clause that you've signed is or is not applicable and whether it should be enforced. But it's a decision that can't just be made blindly. You have to look at every situation and decide what's best for you.